Hello everybody, so I'm going to do part 2 of my investigation, my analysis of Amber Heard's legal case, and I'm looking initially at least at the 4 parts that Andrea Burkhart highlighted as being the 4 most relevant parts. So I've already done the one on the UK case, and I really need to put a little asterisk against what I said, because I said 0% chance. I should have said practically 0, because there is always a chance that there's a corrupt judge, that there is incompetency, or that there isn't a legal argument that I'm not aware of, because I'm not a lawyer. So there might be a legal argument that I've just not heard of. Certainly Amber Heard's team didn't present it, but maybe they will in the trial if we get to that stage, and then maybe that'll change the odds. Certainly, as far as I'm aware, to my knowledge, it's essentially a 0% chance. I'd be shocked if there was any corruption at Court of Appeal level. Goodness, that's not the level you get corruption usually. But it's perhaps not a 0 chance, but it's more like a infinitely small chance. Anyway, on to the second one. So the second one that I'm going to be doing is about whether Virginia was the correct venue. So the argument from Amber Heard's team is that it should have been held in California. And their reason for suggesting that is because Amber Heard lived in California, Johnny Depp lived in California, and most of the defamation was done in California. So the first part of this, I'm going to stop them. The defamation wasn't done in California. Most of the defamation was done globally, because it affected his brand internationally. It hurt him here in Australia, it hurt him every country in the world and every part of every country in the world. So the argument that it hurt him mainly in California is simply false. If you're saying, well, that's because he mainly worked for Hollywood, it's a little bit of an argument, but not really. And also the fact is that Amber Heard, while she was living in California, actually made the defamatory statements physically in New York when she went to the ACLU's offices to write them down. Therefore, New York should be the place if that was the reason. And there's nothing considerably wrong with having Virginia, because that is the location of the Washington Post's office where it was published. Even though she didn't physically go down there, they published it from there. And so realistically, if you were looking at which of those 3 options, you'd say the best option is New York. Now, why didn't she argue New York? Because if she'd argued New York, she would have had some claim to it. But the main issue is, if you went to New York, it wouldn't substantially change the outcome of the case. And neither side wanted to go to New York, because the laws that exist in New York are not quite as favourable to Johnny Depp's case as they are in Virginia. And of course, Amber Heard's team wanted it to be in California because the laws favour her team more. So even though New York was actually the best venue, neither side wanted it. So they had a choice then of one side that favoured Johnny Depp and one side that favoured Amber Heard. And the problem is, given that choice, it was fairer to have it in Virginia, than where at least that's where it was published, than it is to have it in California, which has no connection to the actual defamatory statements, which were physically made they were planned to be made in New York, and they were actually made in Virginia. So you see, there's no argument for it to be made in California, just because that happens to be where she lives. And it's rather irrelevant that that's where he lives, because it was heard worldwide. So that argument's going to fall flat. And the other problem is, yes, we know why she wants to do it in California. I think everybody knows, because California's laws, they have a version of something called anti-SLAPP, which means essentially that if you are saying something that's dishonest or defamatory, you can't really be sued. And if you are sued, it has to be that they have to prove defamation without going to something called discovery. Now, I already talked about discovery in my previous video. That's essentially where you go and make somebody compel them to give evidence. And without that compulsion to give evidence, it's hard to prove Johnny Depp's case. So if you go there and you say, well, we're going to prove this, but we haven't got any evidence, but he's essentially only got the same case, or a very similar case, to the case he had in the UK, and he'd already lost that. So while it's not 0% chance that he would win in California, it's a very small chance. I'd already said that it was about 1 in 20,000 for his chances of winning in Virginia, and he still won that. If we say, and we're looking now at no discovery, you're probably multiplying that by about 50. So you're getting to about 1 in a million. Yeah, that'd be literally his chances of winning in in California. And the problem is, you're comparing something that's 50 times harder on him. But if you're a court of appeal and you are looking at that and you're a court of appeal in Virginia, you're going to say, well, shouldn't it be where we have the fairer case? And the fairer case is the one where there's more discovery, where you get more people witnessed, a longer trial, a jury trial instead of a judge. That's why the US case was fairer than the UK case. But it's also fairer to be held in Virginia than to be heard in California. And essentially there's no substantial difference in fairness between Virginia and New York. There's a little bit of a difference, but it's not enough to change the outcome of the case. Perhaps Johnny Depp might have lost in New York when he won in Virginia, but it's not enough to change the Court of Appeal. And also, they're not asking for New York. If they were asking for New York, there was a much better chance of that winning, but they're not asking for it. And this is the problem. They're doing this because they want to win. Obviously, that's why you ask these sorts of things. But it means that it would be winning unfairly. Because if she'd won in California because of the anti-SLAPP laws, well, it would have been unfair, and that would have been very appealable. So let's say that they had tried it in California, that Amber Heard had won the jurisdiction things to start with, it had been tried in California, and she'd won because they didn't get to discovery. Johnny Depp could have appealed. And on his appeal, he could have said, well, actually, they should have tried it in either Virginia or New York, and a federal court probably would have granted that and granted an actual trial. And then he would have won. So that's the problem. If she'd had it in California, it would have been very appealable. And because she shouldn't have had it in California. And because then she would have won unfairly. So that sort of means, for the same sort of reason as the first one, the Court of Appeal is not going to grant this, because you're going from fair to unfair. And they're looking at fixing up unfairness, not making it worse. And if they are making it worse, well, they're not really likely to do it. Now, I don't want to say 0% chance. I said this in my last video, because it's never absolutely zero. There's always a chance of a corrupt judge, an incompetent judge, or some legal argument that simply hasn't been presented yet, that I'm not aware of, that might be presented by Amber Heard's team, that might change this and might say, well, actually, it should have been heard in California because of whatever reason. And just simply something I'm not aware of. And if he could get a fair trial in California without it being stopped by anti-SLAPP, then, well, maybe that is the better jurisdiction. Maybe California has rules about certain types of evidence that would mean that it would be a fairer trial. So perhaps I shouldn't say absolutely zero, because maybe that's the case, but I don't believe it is. I'm going to say perhaps a little bit more likely than the UK trial issue, but still very close to zero. And I don't want to put a number on it, because, you know, if I say 1,000 to 1, 10,000 to 1, it might be zero. It might be zero. It's either zero or it's something so small as to not to worry about. I'd be really shocked if the Court of Appeal even considered this for a second. I think that this will be an easy one to dismiss. And yet this is one of her 4 big ones. Well, unfortunately, even her 4 big ones are all very easy to dismiss. And there are 2 more to go, but we've got 2 zeros, or 2 essential, practical zeros. They're practically zero. They're so small I can't put a number on them. So either zero or very, very small. Anyway, that's it from me. I'll continue with this perhaps tomorrow. Thanks for that then. Bye bye.